Morning, Enrico. Enrico,
Recording in progress.
Good morning, members.
Good morning, Chair.
Morning, Committee Secretary. I think it's 10 o'clock now, the time for us to...
9 o'clock, Chair.
Yes. No, it's 9, not 10 o'clock. You know, when we are so used to 10. The right thing is to formally extend a word of greetings to all our members, our guests, and also our parliamentary staff. We have an agenda that speaks to the Transport Appeal Tribunal Amendment Bill and also the Marine. And as we can see before us is the Marine Pollution in bracket Prevention of Pollution from Ships Amendment Bill number 52022. The Transport Appeal Tribunal Amendment Bill is Bill number 8B of 2022. So in terms of the thrust of today, we'll mainly be dealing with the negotiating mandate. Having said that, let's then allow the committee secretary to deal with apologies.
Good morning, Chairperson. Good morning, honorable members and colleagues. With apologies, Chairperson, I can report that we did not receive any apologies.
Oh, well, no, thanks. Let's then move in that fashion. Can you fly the agenda again? See, Mama, okay. I see Mama Rekhan has raised her hand. Okay, I suspect it's a mistake.
Okay, thanks, Honorable Chairperson. Greetings to all. I would like to put an apology that I'm attending Finance Select Committee now, and then I won't be able to participate.
Okay,
So,
okay,
yeah,
Mama Rekhan.
okay, thank you very much.
We'll have to then get your alternate. We'll ask Enrico to check with your alternate. Thank you. Let's then present the negotiating mandates, Committee Secretary.
Enrico?
Which one are we starting first with, the transport appeal one?
Yeah, transport appeal one. And
All
also,
right.
Chairperson, I can confirm that both the legal advisors are in the meeting.
Okay.
Yeah.
All right. Okay, these are the mandates. So let's then I request Eastern Cape to start first with the mandate. Can you fly those mandates individually? Honorable Khai.
Good morning, Honorable Chair and honorable members, the committee staff and that of Parliament, as well as the Department of Transport. Thank you very much, Honorable Chair. The Eastern Cape Provincial Legislature mandate from the Portfolio Committee on Transport, to the chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. The name of the bill is Transport Appeal Tribunal Amendment Bill, number of Bill B8B 2022, date of deliberation 29 April 2024. Vote of the legislature, the province vote in favor of the bill, and therefore mandates the permanent delegate to the NCOP to negotiate in favor of the bill. To general comments, the public hearings report of the Portfolio Committee attached here to highlight other issues raised by the stakeholders that ought to be given serious consideration by the Department of Transport. Signed by Honorable X. Malamlela, MPL, Chairperson of Portfolio Committee on Transport, dated 29 April 2024. Thank you very much, Honorable Chair.
Thank you, Honorable Khai, for presenting the negotiating mandate from the province of Eastern Cape. Free State.
Thank you.
Sorry.
Thank you very much, Honorable Chairperson. Good morning, and honorable members and staff. The Free State Portfolio Committee on Public Works, Infrastructure, Road, Transport and Women Settlement. Negotiating mandate to the Chairperson of the Select Committee of Transport, Public Service and Administration. Name of the bill, Transport Appeal Tribunal Amendment Bill. Number of the bill, B8B-2020. Date of deliberation, 12 March 2024. Vote of the legislature. The Portfolio Committee of Public Works, Infrastructure, Road, Transport and Human Settlement, as designed by the Free State Legislature, vote in favor of the bill. Signed by the Chairperson of Portfolio Committee of Public Works, Infrastructure, Road, Transport and Human Settlement in the Free State Legislature, Honorable S. Muleleki, on the 13 March 2024. I thank you very much, Honorable Chairperson and honorable members.
Thank you, Honorable Mushodi, for presenting the negotiating mandate from the provincial legislature of the Free State. Gauteng, Honorable Dango.
Chairperson, can they flight it for me, please?
Right. There you are.
Yeah. Gauteng Legislature negotiating mandate. To the chairperson of the Select Committee on Land, Transport, Public Service and Administration, Public Works and Infrastructure, the Honorable M.K. Moimang. Name of the bill, Transport Appeal Tribunal Amendment Bill. Number of the bill, B8B-2020. Date of deliberation, 11th of March 2024. Vote of the legislature. The Gauteng Provincial Legislature is supporting the Transport Appeal Tribunal Amendment Bill, subject to the amendment below being considered. Clause 2. This will remove a critical layer of oversight by provincial stakeholders and the appointment process. Propose that consultation with the MEC be retained so that there is still some level of consultation with the provinces in line with the principles of cooperative governance and oversight and transparency. Clause 6. 6E, section 12, in brackets 4, in brackets A. Transport Appeals Tribunal should take cognizance of the merits of the different cases and implementation possibilities. Clause 8. Propose that the punitive mechanisms be intertwined either in this clause regulations to deter parties from intentionally delaying the proceedings. Clause 9. Propose that instances where such officers may be removed from offices be added to this clause of Regulations, signed Honorable Greg Schneemann on the 11th of March 2024. Thank you very much.
Thank you, Ambassador, for presenting the negotiating mandate of the Gauteng Provincial Legislature. KwaZulu-Natal. Do we have?
Thank you, Chair.
Thank you.
Yeah, Chair, I'm here.
You can take the floor.
Thank you very much. To the Honourable KK Muimang, MP, Chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. Name of the bill, Transport Appeal Tribunal Amendment Bill. Number of the bill, B8B 2022. Date of deliberation, 22 March 2024. Votes of the Legislature. The Portfolio Committee on Transport met on Friday, 22 March 2024, and agreed to mandate the KwaZulu-Natal delegation to support the Transport Appeal Tribunal Amendment Bill B8 2022, and it's signed by the Honourable Evie Dube, MPL. Chairperson, if I may just inquire, this what I've just read here reads like a final mandate, but it appears that we are looking at negotiating mandates. It seems a bit confusing here, because it's an issue I've raised before, Chairperson, on another bill that we did not agree on. But if you say vote to the Legislature, and then you have below, normally the vote of the Legislature, the final mandate, is signed by the Speaker. Now you've got vote of the Legislature and it's signed by the Chairperson, the committee Chairperson. I'm concerned, Chairperson, that we have a bill here that we all agree on, but that this could be a stumbling block. And I just think it's something to be concerned about, that maybe this isn't 100% correct. It's actually a negotiating mandate, but styled as a final mandate. And I'm just concerned about that, Chairperson, because I'm sure we all like to do things properly. I don't know if you see what I'm saying. I'm just concerned about that. Thank you,
Yes. We note the point that you are raising, Honourable said. I believe with the report that will be sending to the back to the province, will definitely highlight that point, because as you correctly pointed out, from here, once we have consolidated the negotiating mandate, we'll then send the report back to the provincial legislatures so that they are able to give us our final mandate. I believe that the legislatures are more appreciative in terms of our processes, and I don't think there'll be any confusion. The good thing also, most of the PLOs also attend our meetings, so definitely they will take that back to the chair, to the legislatures. Thanks, Honorable Prataseth, for presenting the mandate, the negotiating mandate of the KwaZulu-Natal Provincial Legislature. Limpopo, let me read the Limpopo one. To the Chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. The name of the bill, Transport Appeal Tribunal Amendment Bill. The number of the bill, B8B of 2020. The date of the deliberation, 26th March 2024. The vote of the legislature, the provincial mandate or negotiate in favor of the bill, considering the inputs and comments from the public as attached on the report. Signed by Honorable Siono, Chairperson of the Portfolio Committee on Transport, Safety, Security and License from the Provincial Legislature. The signature of the date is the 26th March 2024. Thank you. Can we then move to Mpumalanga?
I'm just waiting for it to be flighted, Chair.
Thanks, Honorable Bashov. There it is, Honorable Bashov.
Thank you very much, Chair, and good morning to everybody. To the Chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure, Honourable M.K. Moema. Name of the bill, Transport Appeal Tribunal Amendment Bill. Number of the bill B8B/2020. Date of deliberation 12 March 2024. Vote of the Legislature. The Portfolio Committee on Public Works, Roads and Transport, Community Safety, Security and Liaison, after considering the Transport Appeal Tribunal Amendment Bill, Bill B8B 2020, confers on the permanent delegate representing Mpumalanga Province in the NCOP a mandate to negotiate in favor of the bill. And if we can just go up. Duly signed on the 12th of March 2024 by Honourable N. Mashlangu, MPL, Chairperson, Portfolio on Public Works, Roads and Transport, Community Safety, Security and Liaison. Thank you, Chair.
Thank you, Honorable Bashov, for presenting the mandate from the legislature of Mpumalanga. Let's then deal with the Northern Cape one. Northern Cape, to Honorable Kemu Mang, the Chair of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. Negotiating mandate, the name of the bill, Transport Appeal Tribunal Bill. The number of the bill, B8B of 2020. The date of deliberation, the 7th of March 2024. The vote of the legislature. The committee support the Transport Appeal Tribunal Bill, signed by Honorable Senye, the chairperson of the Portfolio Committee on Transport. Thank you, honorable members. Northwest. Honorable Landsman. Okay. To Honorable Kenneth Musman Kapumwimang, the chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. The name of the bill, Transport Appeal Tribunal Amendment Bill. The number of the bill, B8B of 2020. The date of deliberation, 29 February 2024. The Northwest Provincial Legislature vote in favor of the bill. It's signed by Honorable M. Tswaile, the chairperson of the Portfolio Committee on Community Safety and Transport Management, Public Works and Road, on the 8th of March 2024. Thank you, honorable members. That is the negotiating mandates. Then let's then move to Western Cape Provincial Legislature. Do we have Honorable Lund? Let me then read the mandate from the Western Cape Provincial Legislature. address to Honorable K. Muima, the Chair of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. The name of the bill, Transport Appeal Tribunal Amendment Bill. Number of the bill, B8B of 2020. The date of deliberation, 11th March 2024. Vote of the legislature, the Standing Committee on Mobility, having considered the subject of the Transport Appeal Tribunal Amendment Bill, number B8B of 2020, referred to the committee in accordance with the Standing Rule 217, confers on the Western Cape Provincial's delegation in the National Council of Province the authority to support the bill. The committee further proposes the following. This was done on the was signed on the 12th March 2024 by Honorable D. America, the chairperson of the Standing Committee on Mobility. Thanks, honorable members. That is the
Chairperson.
Yes, Committee Secretary.
Northwest send the updated negotiating mandate. I will request Dr. Clark to flight, the updated, negotiating mandate of Northwest, because the one that one it was updated.
Okay. Dr. Clark.
Yes, Chairperson, I'm just pulling it up.
To the chairperson. To the chairperson, the name of the bill, Transport Appeal Tribunal, Amendment Bill, B82B 2022. The date of deliberation, 29 February 2024. The vote of the legislature, Northwest Provincial Legislature, vote in favor of the bill. The proposed amendment. There were no proposed amendments made that were related to the bill, except that the bill must have an expression of the following. One, that the bill should also provide for the Transport Appeal Tribunal to be centralized to offices in municipalities to expedite the quick resolution of disputes. Secondly, that the National Department to speed up the process to open an office in the provinces in all the districts. Is it the province of Northwest or in all the provinces? Can you just help me there, Doc?
Yes, it's Northwest Province, Chair.
Thank you. Thank you. Honorable members, that is the amended mandate from the Northwest Provincial Legislature. I want to believe that Honorable Khai.
No, thank you very much. I think I was not going to comment on the Northwest, but we will deliberate once the department has responded. But I wanted to go back to the issue that was raised, Chair, with your permission, by Honorable Protaset about the KwaZulu-Natal mandate, negotiating mandate. But if you notice, Chair, that all the mandates, they say vote of legislature. It's not only KwaZulu-Natal. These mandates, Chair, are based on the mandating procedure of Provinces Act of 2008. that act, Chair, has two schedules. Schedule 1 deals with the format for negotiating mandates. And also Schedule 2 has a format for final mandates. So I'm saying that there's nothing wrong with how the provinces have structured these mandates. They are based on the schedule that is in the Act. All that they do is to take that schedule and fill in the mandates in terms of each one of those schedules, depending on the stages that the bill is at. So I just wanted to correct that. There's nothing wrong with that mandate of KZN. It is in line with Schedule 1 of the mandating procedure of the Provinces Act of 2008. Thank you so much.
Thank you, Honorable Khai, for clarifying that aspect. I guess Honorable Brataseth, Spheres has been allayed. It's put to rest. But like as I said, we are permanent delegates, and proximity to our legislatures help also in terms of ensuring that that interface during the negotiating process, the briefing sessions, does bear fruits. Thank you, Honorable Khai, for that. I guess let's then give over to the department to respond, and then get a sense from the parliamentary legal advisor. I've seen Mengema is also on the platform. We'll ascertain as whether we have the Chief State Law Advisor's Office also here. But without any waste of time, can we get guidance for the secretary who's leading the department?
Thank you, Chairperson. Mr. Mateves is leading the department on this bill.
All right. The floor is yours, Mr. Matavesi. Welcome again.
Good morning, Chair and honorable members. Am I audible?
Indeed, you are, Honorable. Mr. Matavesi.
Thank you, Chair. The response that we got yesterday was from the Western Cape government and also late from the Northwest province. I had some challenges, Chair and honorable members, for connecting. I'm not sure whether I missed the earlier announcement when you opened the forum, Chair. But nonetheless, I got you when you were dealing with Mpumalanga, Northwest, Western Cape, and KZN. But now I think, Chair, I have to take you and honorable members on the questions that we got, comments and amendments that we got from Western Cape, Gauteng, and Northwest. I'm not sure whether I'm in line with you, Honorable Chair, or not.
Yes,
and we forwarded the same to.
You are in
Sorry,
order.
Chair?
I'm saying you are in order.
Okay.
Mr. Matavesi.
Okay. Okay, thank you, Chair. We have forwarded those inputs to the secretary of your committee yesterday and also in the evening for Northwest. If they can be flighted for me, I don't know, by your committee. The document that they sent to us and our responses.
Enrico? Can you flag the document, Enrico? Okay, there you are. Yeah, let's move up. This is a reflection in terms of the process that we have just gone through.
Correct, sir.
Yes.
On the Northwest Chair, reading the Northwest and also now this morning getting the comments from the Eastern Cape. There are similarities about delays, about the TET devolving to local and to provincial and local spheres of governance and everything. They seem to be saying the same thing but in different ways. But as I'm saying, this Northwest will cover also the devolving of the TET to provinces and municipalities that I found on the public hearings of the Eastern Cape that we just received this morning from your good committee. The response, Chair, as you see, and honorable members, the Northwest was saying therefore that let the TET go to the provinces and have offices at the local authorities. And they support the bill holistically, no comments on the actual bill. Then we responded in the evening with these 5 clauses that now we were disagreeing with the analogy. The TET is not a permanent structure. The TET cannot control the appeal that are flowing in for the hearing by the TET, and the secretary of the department and the chairperson of the TET decide when and how the TET must attend to its processes. The TET doesn't have headquarters at the department, but the department is located for secretariat of the TET. TET go to all provinces. If we receive many appeals in Mpumalanga, many appeals in Northwest, many appeals in Gauteng or Western Cape, TET will have to schedule and hear the appeals accordingly. Also take into account the austerity measures and everything. But TET doesn't have a head office. But it's a question, therefore, TET is appointed by the minister and is located in the department for secretariat purposes. But TET go and hear appeals everywhere. And people who put appeals on the TET, they can use email, they can use fax, they can post. Email is an easy way of you forward email now to me now, I got it now within seconds. And it's a promptness process. It make process to lodge an appeal to be faster and quicker. But members of the TET are not full-time, as I've already stated. They are part-time. They are having their offices in their own state, but they come when there is work to attend, to hear the matters, and then they go back to their respective places. That's why, Chair and other members, I'm saying both the comments that I've just glanced through the Eastern Cape and the Northwest are attended by this comment that we have made in the evening to the Northwest. Thank you, Chair and other members. If you can go down to the Western Cape. On the amendment of 1 seat, Chair, the department agrees thereof. We take a point of raised by Western Cape on that one. On the one of the provincial, the second one, we disagreed, Chair, vehemently on that one, due to the fact therefore that according to the NLTA as stated there, at the end of the day, there won't be any POPs in South Africa going forward. That is a 2009 Act. There was a period where all the POPs must migrate to the PREs. Now, if one POP, for example, hasn't migrated, we can't have a provision for that in a long term, because that is also has to migrate to the PREs. That's why the department still felt therefore that it disagrees with the proposed amendment and still took to the resolution that it had made of deleting the reference to POPs and put PREs. Thank you, Chair. 1B, Western Cape. If you can go down. Western Cape Province 1B. Where they said there can be same thing, same analogy, Chair. The same reasoning above. We disagree with that proposal, or on the same analogy that was stated in the preceding paragraph. Comment on comment that we I just pronounced on the above comment, Chair. That still also attend to be, and also attend to the following one, same response as above hearing. the same one that goes to the comment that is made by the proposal member of Western Cape. We still maintain, therefore, that we have to remove the POBs. We are in the PRE now processes, and all the act now talk about the PREs, no longer about the POBs. The NLTA was abolished by the NLTTA was abolished by the NLTA in 2009, which was the Act of 2000, and we felt therefore that we have to continue with the new provision of the NLTA in compliance with those. Next clause 2, amendment of section 4. Yeah, same. I've talked about that one. Amendment of section 4 by the Gauteng. On that one, Chair, the department has already considered on that one. That for one was removed for consulting the MECs. Is still there. The department long time ago agreed with that proposal when it was first made, and that proposal, that amendment is no longer part of the amendment that we're dealing with, has been removed altogether in the A list by the MCOP when we're in Parliament. That we agreed with, that one still stands on the Principal Act. There's no problem with that one. Thank you, Chair, and honourable members. We can go now to section 9 of Principal Western Cape Province. Western Cape Province, the department made a comment. Also on that one, Chair, we agreed with sorry, Chair.
Okay.
The department agrees with retaining sections 9.1 as it is. We see no problem with that. And then the new proposal that has been made now by the Western Cape, the department also agrees, because we're retaining the 9.1, and the department agrees now to that proposal 9.4, so that it can be inserted as it is. The department sees no hindrance to that. Substitute section 11, Western Cape, further down. Yes, department also suggested a wording hearing. Yeah, we on that one also, Chair. It was a question of English, trying now to put us the national or provincial, of which we were just putting any relevant. But we felt therefore that we agree with that proposal. The department will have to agree and consider the proposal made. No qualms on that one, Chair and honourable members. Next, the Gauteng should take cognizance of the merits of the different cases and implement. That department knows the comment thereof, and there's no harm with it. That's what's going to happen, mostly on the regulations. Western Cape, section 13. We got what the Western Cape is saying on the automatic suspension, but now we decided to sponsor, subject to the legal advisors of the department of the Parliament that can assist us whether we have couched it correctly. We've sponsored a phrasing at the end where we underline it. Can you go down? Where you underline it? Can you go down? Can the slide go down a little bit? Yes. Where we've sponsored that underlined, except where the respondent opposes such a suspension. We are open there, Chair, to the parliamentary legal advisors to advise us. If they are agreeing with us, is fine. If not, we're prepared to take what proposal they can make. But in trying to respond to the comment there, we feel therefore that is rational. Then we have sponsored ourselves to put that underlined statement at the end of the clause. Gauteng, Province 8, proposed punitive mechanism. Department notes and soon to be drafted regulation will cater that. That is going to be part of the regulations going forward, Chair and honourable members. Western Cape, there's an error in the wording of the. We differ with that one, Chair, because we felt therefore when we read it, there's no error. That one emphasized frivolous, vexatious, or relevant actions on the part of the person during proceedings, and we differ with the analogy that there's an error in line 37, Chair and honorable members. Gauteng, Principal Act sitting with the tribunal proposed that instances where such officers will be removed. On that one, the said official chair will be appointed through the Public Service Act, and applicable labor laws will be utilized in cases of discipline and removal, like any official. Sorry, Chair. Like any officials in the public sector sphere, because TAT members are appointed through the TAT Act. They are not officials. Officials, Secretary of the TAT is appointed through the Public Service Act, which become the official of the department and accountable to the DG. Then all processes of the person appointed, not following the protocol of the department or the protocol of the TT, will be removed according to the labor laws applicable to Public Service Act and related pursuits. Thank you, Chair. And honorable members, 9 Western Cape Province proposed laws not supported. Any investigation required? The department also here, after going through, the department agrees with the contention of maintaining Section 16 as it is in the Principal Act. We don't see any qualm on that one, Chair. As now, as you see, it's a longer. The Western Cape went on justifying their proposition, which the department agrees with it, and at the end, the Chair, on the cases that have been quoted and how they are seeing it, of which the department didn't have a problem with it. And now the proposal at the end, that the recommendation that they are making, can you go down? Right at the end, they're making a recommendation after they put the whole story, of which the department has got no problem with it. Go further down. Go down. Yes, go down. Go down. Yeah, yes, there. They are putting a recommendation there on Section 16, of which the department agrees to that proposal of a new provision, where now from time to time the DG to designate officials of the department to perform any investigation requirement, because the analogy argument, Chair, was that now it seems as if now the provision was trying to usurp the powers of the chairperson. That's what the Western Cape was saying in all their contention regarding this clause, of which the department didn't have any problem with that analogy that they are putting, but now they are making the recommendation therefore that keep Section 16 as it is, but add this one so that it can try to help to get more staff for the TT at the end of the day, without now tampering with the actual Section 16 of giving powers to the tribunal when so deemed necessary. But now the DG from time to time will the tribunal from time to time to request the DG to designate official of the department to perform investigation required by a tribunal that be necessary. The department didn't have any problem with that new insertion of the provision. Chairperson, honorable members. That's that on the side of the department, Chair. As I've stated, I've just perused the Eastern Cape one. It's more on comments and the question of operating license being delayed, which is not the mandate of the TAT. The TAT deals with appeals. The delays of the operating license and all the processes are the domain of the PREs, which are located in the provinces. And also when the NPTR in the department is fully functional, it can take those delays and try to work them out. But now on this amendment, Chair, what we have introduced on the definition is the omission. Now the failure to act becomes the decision. Now in future, trying to attend to the delays that people are experiencing getting the operating license from the PREs. If a person comes to the TT and the TT now will have to take that appeal and engage the entity concerned, because the failure to act can no longer now because now we have increased the definition of what can come before the TT. If you look at the amendment currently before you, we have increased for that. Therefore, now we are trying now in future, the department will try to have less of the delays by the PREs in attending to the applications of the people. Because once that comes to the TT, they understand that the TT will engage the province, say, PREA, there's this challenge, kindly attend to it. Because if you fail to attend to it at this particular time, number one, it would be wrong to the operators on the ground, and number two, it would be failing to discharge your duties as enshrined in the legislation, and therefore the TT has to do something about that one. But that is a future process. It's not how it's going to be done. The regulations are going to spell it out. But now it's not part of this hearings. But I was trying to peep through to the coming process, Chair, that will unfold in future. But for now, the delays are part of the provincial competency, and also at most the NPTR when it's full functioning. But the TT will deal only and also with the decision that has been made by the PREs, whether to grant or to refuse an open license. That is the mandate of the TT, and is still continuing with that fashion, Chair. Thank you, Chair and honorable members. Those are my comments, Chair.
Thank you, Mr. Matebesi, for the response. Let's just ascertain one aspect. Committee Secretary, it is Ms. Ngema that is taking over now.
That's correct, Chairperson.
Mengema.
Thank you, Chairperson. Greetings to yourself and everyone on the platform. Chairperson, I think I must just preface that I am on my vacation leave, but I'm here so that I could assist the committee. And from what I've heard, Chairperson, on the deliberations and the parameters for the negotiating mandates and the responses of the department, I think for purposes of considering whether the possibility for the C list is there on the direction of the members, as well as when we do the clause by clause, just 4 things that they raised that I need to speak to. I think it's the definition or the addition of the permit in 1C of the proposed amendments. I will look into that, Chairperson. But the other one, in respect of provincial legislation as well as national legislation, I think the current phrase, basically, it is inclusive of both, or even the municipal bylaws, because if you understand what legislation is, it's speaking to every other legislature that is enabled and mandated to make legislation. And this being a concurrent functional matter, I think the current phrase that speaks to relevant transport legislation is sufficient to cover anybody and all the legislatures that are making legislation in this respect. In respect of the third one and the fourth one, Chairperson, which is on section 13 as well as section 16, I think for those ones, we will need to apply ourselves together with the state law advisor, and then we will indicate, Chairperson, whether it is also necessary to look into the issues that have been raised. And if that is the case, then during the clause by clause deliberation, we may probably have some suggestions in line with what the department has also indicated as they support and as they make some of the recommendations. That is all I would love to say right now, Chairperson. Thank you.
Thank you, Ms. Ngema, on that. Do we have the rep from the Chief State Law Advisor, Committee Secretary?
No, Chairperson.
Right. All right. Let's then open the floor to members. Any reflection that members would want to make on the responses from the department, but more so also the parliamentary legal advisor, Mrs. Ngema. I think critical to that is also a window of opportunity for them to apply their mind to both was 13 and 16. So I think it will be important then just to get a sense from members. Honorable Khai?
Thank you very much, Chair. I think it's going to be a bit difficult for now to engage, Chair, given that the legal advisor is still to study the responses of the department and advise the committee accordingly. So I would rather suggest that perhaps on this bill we wait for the legal advice to study and then develop responses as well to these negotiating mandates, the response to the negotiating mandates by the provinces, and also the responses of the department. So I would like to suggest that process check going forward. Thanks.
Thank you, Honorable Khai. Members, that's a concrete proposal from Honorable Khai. I guess it makes sense. Let's check in terms of the process, Committee Secretary. Or probably get guidance from Ms. Ngema. We appreciate your commitment and the fact that you are also on vacation. It will be important just to get a sense whether by Friday, all the team would have had sufficient opportunity so that we are then able to, because I see we have a meeting on Friday. Committee Secretary?
Thank you, Chairperson. I think that's correct, Chairperson. We do have an opening for Friday because I'm in the meeting that we're supposed to deal with the CLIS on the railway safety bill. Then we won't be able to do with that because there's no amendment. So we can take this opportunity to use that day if the department, I mean, if the legal team is ready on Friday. But if they are not, then it means we can try maybe to have our meeting on Tuesday, 7 April. Then we deal with our C list on Wednesday, 8 May.
Yeah, the idea is that we also give provinces enough opportunity to engage. Is Friday too early, Ms. Ngema?
Thank you, Chairperson. Because there's still the process to do clause by clause in light of whatever we may have proposed, Chairperson, because what we propose must also be directed by the clause by clause instructions from the committee and the adoption thereof. I think a draft for Friday and the meeting to arrange and adopt the clause by clause position can work. I will try my best to do what needs to be done, and then we can go ahead with the meeting on Friday.
All right. Okay, members, are we happy with that?
Chairperson, I may have a challenge. For
Okay.
Friday. I have been scheduled to speak in a mosque on Friday.
All right.
So if I can leave by 12 o'clock.
All right. No, it's fine. Then let's then agree that.
Chair,
Honorable
sorry.
Bishop?
Yes, please note my apology for Friday. I'm unavailable on Friday.
Okay, I think let's then agree that probably we will interact. But I see Honorable Hayes also raised his hand.
Yeah, I was also going to, because we agreed last week that we won't have a meeting. So the program, as you know, all of us
has changed, yes.
of elections.
Yeah, let's stick to our program then.
Yeah, maybe we can rather take Tuesday and then Wednesday.
All right.
Yeah, next week. Yeah.
Thank you, Honorable Khai, and members for that. Let's then agree that we then allow the deliberations to be dealt with once we have the responses from the parliamentary legal advice. We will then meet both next week and Wednesday. Thank you. The next item on the agenda, Honorable Khai.
Sorry, Chair, I don't think there will be too much. Maybe the approach I want to suggest is that because there are not too much in terms of the proposal that are made.
Yes.
Most of them come from the Western Cape. I think there will be one or two from the Gauteng, as well as that of Northwest and Eastern Cape. So therefore, our deliberation will be around those after the responses by the legal advisor, and then if then were to vote, I would suggest that we will then do the clause by clause on those areas as to whether we agree or not agree with those proposals, both by the provinces or the department or the legal advisor. And then we then vote for the whole bill instead of going clause by clause for the whole bill. We do clause by clause for those specific clauses where there are proposals, and then we vote for the whole bill then. After we finish with the clause by clause that relate to the proposal that have been made by the provinces and the responses thereof from the department and the legal advice. I think that way it will be much quicker. Thank you so much.
Thank you for that guidance, Honorable Khai. It makes our work much more easier. Then let's close it on that note. If members agree, agreed members.
I agree, Honorable Chairperson.
Thank you.
Chairperson.
Yes, Committee Secretary. Yes,
after the input from Honorable Khai, I just want to check whether we're gonna still meet on Tuesday or we're gonna meet on Wednesday.
Yes, our next meeting is on Wednesday.
Yes.
Yes. I think let's of the advantage of Tuesday is that at least if there is any of course mindful of the fact that members have already made the arrangement in terms of their programs. So let's stick to Wednesday.
Okay. No,
yes.
Chairperson, I may have a clash with the Bella bill, but maybe
Bella bill.
Together with my colleague, Mr. Hlupega, maybe let's see whether it's Tuesday or Wednesday. Please leave that anyway, otherwise I'll be dying.
Our apology, Ngema. We will get guidance from the committee secretary and Ms. Ngema, so that we tighten the date. Let's then move to the next bill, the marine pollution. Can we deal with the negotiating mandates? Then let's flag them. Honorable Khai, negotiating mandate from Eastern Cape.
Thank you very much again, Honorable Chairperson. The negotiating mandate from the Eastern Cape Provincial Legislature read as follows: to the Chairperson, Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. Name of the bill, Marine Pollution, Prevention of Pollution from Ships Amendment Bill. Number of bill, B5-2022. Date of deliberation, 29 April 2024. Vote of the legislature. the province vote in favor of the bill and therefore mandates the permanent delegate to the NCOP to negotiate in favor of the bill. General comments, the public hearings, a report of the portfolio committee attached here too highlights other issues raised by the stakeholders that ought to be given serious consideration by the department, signed by Honorable Ane Malamlela, MPL, Chairperson of Portfolio Committee on Transport, dated 29 April 2024. Thank you very much, Honorable Chair.
Thank you, Honorable Khan, for presenting the mandate, the negotiating mandate on the bill, the Marine Pollution Bill from the Eastern Cape Provincial Legislature. Free State, Honorable Mashori.
Thank you very much, Honorable Chairperson. Free State Legislature Portfolio Committee on Public Works, Infrastructure, Road, Transport and Human Settlement. Negotiating mandate to the Chairperson of the Select Committee of Transport, Public Service and Administration. Name of the bill, Marine Pollution Prevention of Pollution from Ship Amendment Bill. Number of the bill, B5-2022. Date of deliberation, 12 March 2024. Vote of the legislature, the Portfolio Committee on Public Works, Infrastructure, Road, Transport, Human Settlement as designated by the Free State Legislature, vote in favor of the bill. Signed by the Chairperson of Portfolio Committee on Public Works, Infrastructure, Roads, Transport and Human Settlement in the Free State, Honorable S. Muleleki, on the 13th March 2024. Thank you very much, Chair and Honorable members.
Thank you, Honorable Mashori, for that presentation from the legislature of the Free State. Gauteng.
Can they please write it for me, Chairperson?
There you are, Honorable Dango.
Thank you, Chairperson. Negotiating mandate to the Chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure, Honorable M.K. Moimang. Name of bill, Marine Pollution Prevention, in brackets, Prevention Pollution from Ships Amendment Bill. Number of bill B5-022. Date of deliberation, 11th of March 2024. Vote of the legislature. The Gauteng Provincial Legislature supports the principle and the detail of the bill and therefore votes in favor of Marine Pollution Prevention, Pollution from Ships, in brackets, Amendment Bill, signed Honorable G. Schneemann, 11th of March 2024, Chairperson of the Portfolio Committee on Transport and Logistics, Gauteng Provincial Legislature. I thank you. Honorable Moimang, you've been muted.
Thank you, Ambassador. Thank you for the presentation on behalf of the Gauteng Legislature. It's a negotiating mandate on the Marine Pollution Amendment Bill. KwaZulu-Natal, Honorable Prataseth.
Thank you, Chair. To Honorable M.K. Moimang. Name of the bill, Marine Pollution Prevention of Pollution from Ships Amendment Bill. Number of bill B5-2022. Dated deliberation 22 March 2024. Vote of the committee. The Portfolio Committee on Transport met on Friday, 22nd of March 2024, and agreed to mandate the KwaZulu-Natal delegation to support the Marine Prevention of Pollution from Ships Amendment Bill B5-2022, signed by the Portfolio Committee Chairperson, Honorable E.V. Dube. Thank you.
Thank you, Honorable Prataseth, for presenting the negotiating mandate on behalf of the KwaZulu-Natal legislature.
Just
Limpopo.
one question, Chairperson. Honorable Brownshed actually read out the mandate from KwaZulu-Natal, but inserted his own words there in it.
Ambassador, let's move forward. Limpopo
Sorry,
legislature.
Chairperson.
Honorable brother said. I
refuse to say it's a vote.
Thank you, Honorable Chief.
I will not confirm a falsehood.
Yes. Limpopo legislature, to the chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. Name of the bill, Marine Pollution, in bracket, Prevention of Pollution Amendment Bill. The number of the bill, B5 of 2022, the date of deliberation, 26 March 2024. The vote of the legislature, the provincial, the mandate of the legislature is to negotiate in favor of the bill. This is to mandate the provincial NCOP permanent delegates to negotiate in favor of the bill, considering the inputs and comments from the public as attached on the report, signed by Honorable Seono, the chairperson of the Portfolio Committee on Transport, Safety, Security and Liaison, dated the 26th of March 2024. Thank you. Mpumalanga, Honorable Boshoff.
Radio Chair, just waiting for the mandate to be flighted.
Thanks.
Sorry for the background news, but as you know, we are doing 2-3 things at a time. Okay, to the chairperson of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure, Honorable M.K. Moyamang. Name of the bill, Marine Pollution, in brackets, Prevention of Pollution Amendment Bill. The number of the bill is B5/2022, and the date of deliberation was 12 March 2024. The vote of the legislature, the Portfolio Committee on Public Works, Roads and Transport, Community Safety, Security and Liaison, after considering the marine pollution, in brackets, Prevention of Pollution, close brackets, Amendment Bill, Bill B5/2022, confers on the permanent delegate representing Mpumalanga Province in the NCOP a mandate to negotiate in favor of the bill. Thank you. Duly signed on the 12th of March 2024 by the Honorable N. Mashlangu, MPL, Chairperson, Portfolio on Public Works, Roads and Transport, Community Safety, Security and Liaison. Thank you, Chair.
Thank you, Honorable Boshoff, for presenting the Mpumalanga negotiating mandate on the Marine Pollution Bill. Northern Cape, in flight the mandate of the Northern Cape Provincial Legislature. To the Chair, Honorable Kemima, the name of the bill, Marine Pollution Prevention Bill, number of the bill, P5 of 2022, the date of deliberation, 7th March 2024, the vote of the legislature. The committee supports the Marine Pollution Prevention Bill, signed by Honorable L. Sinye, the chairperson of the Portfolio Committee. Thank you. Northwest. The negotiating mandate from the Northwest Provincial Legislature to Honorable Kenneth Msimana-Khapi Muimang, Chair of the State Committee on Transport, Public Service and Administration, Public Works and Infrastructure, The name of the bill, the Marine Pollution, in brackets, Prevention of Pollution from Ship Amendment Bill. The number of the bill is B5 of 2022. The date of deliberation, 29 February 2024. Vote of the legislature. The Northwest Provincial Legislature vote in favor of the bill. Signed by Honorable Tswaile, the Chairperson of the Community Safety and Transport Management and Public Works and Roads, on the 8th March 2024. Thank you. Let's deal with the Western Cape negotiating mandate. The mandate of the Western Cape Legislature to Honorable K. Muima, the Chair of the State Committee. The name of the bill, Marine Pollution, in bracket, Prevention of Pollution from Ships Amendment Bill. The number of the bill, B5 of 2022. Date of deliberation, 23rd February 2024. The vote of the legislature. The Standing Committee on Agriculture, Environmental Affairs, and Development Planning, having considered the subject of the Marine Pollution, in bracket, Prevention of Pollution from Ships Amendment Bill, number B5 of 2022, refer to it in accordance with Standard Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the amendment bill. The committee further proposes consideration of the following in respect of the amendment bill and further regulations, signed by Honorable AP van der Westhuizen, the Chair of the Standing Committee on Agriculture, Environmental Affairs and Development Planning, dated the 6th March 2024. Thanks. That is the mandate from the Provincial Legislature of the Western Cape. So therefore, all the 9 province negotiating mandate is in support. Let's then give over to the department to then respond to the negotiating mandates, and then thereafter we'll then give over to the parliamentary legal advisor. Guidance, committee secretary.
Thank you, Chairperson. Mr. Ntuli is the one who's leading this part.
Thank you. Mr. Ntuli, you can take the
Thank you very much.
floor.
Thank you very much, Honorable Chairperson, and good morning to all the members. May I kindly request the Secretariat to please flight the responses that we provided yesterday. And I must as well just indicate that having had an opportunity of going through early this morning of the Eastern Cape mandate submissions, we observed that there was one additional comment and a response that we would provide. So members have not seen our response in regards to that one matter that was raised by the province of the Eastern Cape.
Thank you.
It doesn't provide a proposed amendment, but it's a comment, and our response would be to give information that, in our opinion, would satisfy the concerns that are raised.
Thank
so
you.
without further ado,
my apology. I see Mr. Matebisi has raised his hand.
Thank you, Honorable Chairperson and honorable members. Chair, I would love to make an honest request to be excused due to departmental engagements. I don't know, so that I leave the forum now instead of joining the forum until the end. I'm at your hands, Chairperson.
Thank you, Mr. Matebisi. You are duly released. Thank you.
Thank you, Chairperson and honorable members.
Thanks. You can continue, Mr. Ntuli.
Thank you very much, Honorable Chairperson. If you could just scroll down, please. Yes. I think here there is a comment, under general comments from the Western Cape, where the province was submitting their concern with regards to numbering, particularly on the annexes to the proposed amendments. And the response of the department is that the numbering throughout the bill has been checked and is correct. However, cross-referencing in the annexes to the convention is beyond our control, and we therefore consider it accurate. And the reason really for this one is that the annexes are taken verbatim because they are the legal text of the annexes to the Marine Pollution Prevention Convention of the IMO, and that any changes to that would have implications on the enforcement thereof. So we understand it the way it has been prepared, and we consider it to be accurate. Now, as regards to Clause 1, the Western Cape Provincial Legislature Portfolio Committee is bringing to our attention that the words party and certificate are used extensively throughout the bill, and they were recommending that we need to provide a definition to these terms. Our response is that the usage of party in the Principal Act mirrors the generally accepted usage of the term in the convention as meaning reference to a state party to the convention. The usage of the party in this bill has not therefore deviated from this globally accepted meaning given to it by all IMO member states. Based on this, therefore, we do not consider that its use will confuse as to its meaning in the bill, because the only meaning that is given to it is the party to the convention, and there's no other use of the title party that may then bring about the feared confusion from the Western Cape. And if you can proceed. Now, the IMO has not then, this is now in relation to the suggested definition of the certificate. Our response is that the IMO has not defined this term in any of its conventions. The only definition is found is in the guidelines issued by the IMO. Now, any text that is in the guidelines is taken as non-mandatory by all parties to the convention. This means that the global maritime practice has no binding general definition of the term certificate. And because we are regulating an international shipping industry, it would not be wise to introduce a regulated and binding definition of this term in our legislation. So this is just to then align with the international best practice that this term has not really been defined and is accepted to have the meaning that is attached to it in the relevant provision of the clauses to the bill. We proceed then also to the insertion of a new Section 2, which should be 2A, where the incorporation of the convention into law, particularly on the conferment of the technical standards, the power to issue by the South African Maritime Safety Authority. Now, Western Cape draws us to Section 2A2, which is a new insertion, which states that the minister shall amend the schedule upon amendments to the convention. That province was recommending that we need to insert a time frame for such amendment to take place. And our response to that is that it would not be wise to legislate time frame for matters that are beyond the control of the state. The schedule will only be amended when necessary following the amendment of an IMO instrument in the schedule, because the schedule contains all the IMO conventions and protocols. So it is only the IMO that would cause that states would then amend their relevant text of the convention, which is contained in the schedule to their domestic legislation. So the way it's been provided at the moment in the bill, we think it is sufficient and empowers the state to be able to give effect to the provisions of the convention and to ensure that the convention is kept up to date. Western Cape also has a comment and some suggestions on Chapter 3 on equipment and control of discharge of sewerage, and that pertains to what the Western Cape draws to our attention under Regulation 1, where reference is made to disinfection of sewerage being discharged in coastal waters, and a reference to the fact that some ships may discharge significant volumes of partially treated sewerage. Disinfection will be undertaken prior to releasing the sewerage into coastal waters. When disinfection is being undertaken, consideration must be given to some of the chemicals that are used in the process, such as chlorine, as they may have harmful effect on ocean ecosystems. And furthermore, on onboard treatment facilities and processes for ships with large sewage loads, such as passenger ships, must consider the removal of endocrine disrupting substances from the sewerage streams before it is treated and released. On reading these, I think it's more, I think is a demonstration of the understanding of the intended regulation of how discharge would be undertaken, and does not necessarily recommend a particular amendment from Western Cape, and that our response therefore is that the discharge guidelines which the IMO issues already regulate that only affluent sewerage would be released in a regulated manner, and this is this does not require any particular amendment, because the regulation itself is clear enough to ensure that only affluent water would be released into the environment, to the marine environment, in the manner in which is detailed in the actual regulation. And I would further touch on this point because the Eastern Cape raises another dimension which relates to the reception facilities which ports must have in order to manage the discharge of untreated sewerage from ships, and this calls for the treatment facilities, reception facilities that each contracting state to the convention must provide. And I will just give that clarity as to how this is regulated in the convention, and we consider it to be sufficient to bring comfort that this would be a regulated discharge other than what is being feared here. If you can go up again on the comments on the Appendix 4, which relates to the type approval and operating limits for shipborne incinerators. The Western Cape brings to our attention that the appendix to the Annex 4 provides for the type of approval and operating limits for shipboard incinerators, and that no mention is made of the type of emission abatement equipment permitted, such as scrubbers, and the requirements relating to the disposal of waste generated by mitigating equipment in a responsible manner. And submitting that provision to be made for these matters, and that a requirement is inserted to make the testing of fuel mandatory. We then provide a response, because this speaks to both annexes 4 and 5, but in this case, I'll just give the information that would satisfy that the annex itself is tight enough to ensure that all the emission abatement equipment that ships must have is tight-proof to ensure that there would be no leakage, and also I'll deal with the issues of testing. In this regard, then, we respond as follows. It should be further noted that the use of emission abatement measures is covered in the IMO guidelines, and annexed to the IMO 2015 guidelines articulates the purpose that specifies the requirements for the testing, survey certification and verification of exhaust gas cleaning systems. And these are the abatement systems under Regulation 4 of MAPOL Annex 6 to ensure that they provide effective equivalence to the requirements of Regulations 14.1 and 14.4 of MAPOL Annex 6. Remember that the use of this abatement equipment is to help ships in their current form, to which their engines were designed to use non-compliant fuels, but the installation of the exhaust gas cleaning systems would then help a ship to remove all the sulfur fuel that is in the fuel that they are using, so that the oil that will be consumed by the ship during its voyage would be compliant. So these guidelines then help as to how these treatment systems, exhaust gas cleaning systems, should be able to do. So, because they would then be approved by the administration of the ship. So on our side, we'd have to test that these gas cleaning systems have the required certificates, and the regulation empowers us to do that following the guidelines that the IMO has provided in 2015. And further, also in Appendix 6, Western Cape raises the issue of emission control areas. These are the areas that coastal states may demarcate to limit the emission of these harmful substances into the atmosphere. Now, Western Cape then draws our attention that the appendix provides for the emission control areas, And it should be noted that there are currently no emission control areas along the South African coastline. It is submitted that such areas should be declared at least within the vicinity of the major South African port to prevent air and noise pollution, and that this is provided for in the maritime legislation. Now, here our response is that the enactment of the bill itself into law will assist South Africa towards the identification and introduction of possible protective measures in particularly sensitive sea areas, and consider new areas, including the emission control areas. We should as well just bring the comfort to the committee that already South Africa, the Southern Ocean area, is a particularly sensitive sea area, in which was demarcated already following the submission by South Africa in 2012 to the IMO. But the emission control areas is what the enactment of this bill would help us have the power to assess and introduce along the coast of South Africa, following all the guidelines that are required for states who wishes to demarcate emission control areas. So if we can proceed to the next page 5. Under page 5, let me just scroll down again. Now, page 5, and there's a comment under general there, which noted that the bill will give effect to Annex 4 for the prevention of pollution from ships, which addresses the prevention of sewage pollution from ships. And that province was submitting that pollution abatement technology should be used to reduce environmental impact from the incineration of waste, especially those that impact on climate change. We just draw the attention of the committee in response to the Western Cape that Regulation 16.5 already, as regards the shipboard incineration of sewerage, sludge, and sludge oil generated during the normal operation of a ship, in case it takes place, may take place in the main or auxiliary power plant of boilers, but in those cases shall not take place inside ports, harbors, and estuaries. So this just confirms that that incineration happens on board the ship, and it is regulated by the existence of approved systems that are on board the ship. Now, we regard this to be sufficient prohibition provision in Annex 6, and therefore do not consider necessary to impose further prohibitions. The definition of ports is inclusive of the port limits and out of port limits where the Republic has comprehensive jurisdiction. So in this case, as we have indicated, that the Regulation 16.5 does regulate this, and it only can happen within the ship and in demarcated areas that are outside the ports. And with this, then, is sufficient to protect an exposure of the Republic to any of these substances that may be emitted during the incineration process. Western Cape also acknowledges that the amendment of the bill focuses on MARPOL. If you can just scroll up again. And I think here it's a repeated comment on the noise, that they would wish that this we also use this opportunity to introduce regulations for noise pollution, more particular underwater noise. And this concern, Honorable Chair and the members, we have consistently and adequately addressed both during the portfolio committee deliberations, where we indicated that unfortunately, the scope of these two annexes does not cover these matters. And in any event, these matters are not regulated globally. So there are no international agreements on noise pollution and underwater noise pollution. The only guideline that is there is onboard noise, which is mainly meant to protect seafarers who work on board ships, and these guidelines are followed by all ship owners. So I think in our explanation we understood that this was accepted, that we can't introduce matters that are not in the principal convention itself, because our intention is to domesticate what we have already signed up to, which regulates international shipping. Western Cape also continues to comment on Section 3 of the Principal Act, which pertains to the regulations. And in this regard, the introduction of the power of the minister to make advisory committees is being raised, and in the view of that province, they were suggesting that maybe we needed to have detailed procedures and responsibilities detailed in the act as to how these committees, advisory committees, would be established, and so forth and so forth. And our response, I think, firstly, in dealing with one of the issues in terms of the capacity for local communities, there we said that training and support to local communities, once the bill is enacted into law, is a matter that is customarily undertaken by the South African Maritime Safety Authority as part of its outreach program, and through roadshows they would introduce and explain the intentions of the new legislation, and take all the communities and those that to be regulated to understand exactly their responsibilities and what they would be held accountable for. And as regards the clause on the advisory committees, which is a new in Section 3B, as I've indicated, the response there is that the advisory committees that are envisaged in the bill are of an ad hoc nature, and for that reason, the department considers that the proposed amendment is suitable for committees of a permanent nature, unlike in this case where these committees will be constituted as the need arises. So we therefore consider that the requested proposed amendment would not be in line with the intended meaning and rationale behind the advisory committees that are envisaged here, that these are ad hoc committees that the minister would be empowered to constitute. So once they've addressed a particular matter, they'll then be disbanded, and a new one also would then be established as and when appropriate. And under Annex 4 also, Western Cape had commented particularly on Regulation 3, which deals with exceptions. If you can scroll a little bit down, and that pertained to the regulation provides for exceptions, and the province was submitting that the intention to discharge sewerage as a result of damage to a ship or equipment should be communicated verbally to the South African Safety Authority. This is now in cases where the ship is in distress and has to shed out the discharge of sewerage and other substances. And the suggested amendment is to include a verbal communication to SAMSA, Southern Maritime Safety Authority. Our response is that it would be wise not to accommodate this proposed amendment for the reason that various methods of communication are envisaged, and that by regulating that only verbal communication be used may be too restrictive and not serve and may have unintended consequences. So you would want to use all means of communication to reach out to ensuring that in such cases where the discharge is for safety, it will be communicated appropriately. Scrolling down under Annex 4, also particularly on surveys, particularly under 4.1b, Regulation 4.1b, the regulation pertains to the renewal surveys for certification that are to take place at intervals specified by the administration, but not exceeding 5 years. So this now relates to a reference to an administration, which is the flag of the ship, where the regulation says all certificates to be issued must not be issued for more than 5 years. The validity must not be for 5 years. The department, as a response, considers this to be a comment not warranting or attracting a particular amendment, because so the maximum is just 5 years. It can be shorter, but so we don't think that we need to regulate. We need to have a particular amendment to what is already provided here. Regulation 8, moving quickly, deals with the duration and validity of certificates, where again the Western Cape comments on the expiry of the sewerage pollution prevention certificate, and the reasons. So they are proposed that we need to have reasons on why the administration has an expired certificate. And our response here is that the regulation anticipates that the master of the ship is obligated to account for non-compliance, and we would not like to adopt a spoon-feeding approach in regulations such as in such an international industry. We would expect the master would be expected to explain why the certificate is expired. Under Regulation 8.1, Western Cape is also commenting on the validity of the sewerage pollution prevention certificate, and that they would like the advisory committees, which we have addressed to earlier on, to consider shortening the period. And our response is that the period may be shorter than the specified period in the regulation, for the simple reason that the period in the regulation is a maximum period of validity of all certificates. So this matter is well regulated, and the advisory committee would not be the appropriate structure to deal with this. And then on Regulation 12 on ozone depleting substances, Western Cape opines that the regulation indicates that the records of ozone depleting substances are to be kept by ships, and they should be approved by the administration. And they recommend that the regulation explicitly states the personal authority to whom such records should be submitted. We just want to clarify here that the reports are not necessarily, the records are not necessarily submitted, but they are made available for inspection, because these records need to be kept on board the ship. So an inspection officer would then go on the ship and demand to see all these documents, but not to have them submitted to them. So it will just be for inspection purposes, and that they are safe because they are part of the history of the ship, which is referred to as the continuous synopsis record that all ships must keep on board. And in terms of these, they have to be cared for for about 3 years for possible inspection. Regulation 16 also on is a comment on board ship incineration systems, which we have also addressed. I think we've drawn the members to 6.5. So the same response that we had given applies here, where the Annex 4 does regulate quite strictly the incineration on board the ships. Regulation 18 on fuel oil availability and quality, and where the Western Cape draws our attention to subreduction 9B, which refers to suppliers providing bunker delivery notes and samples certified by the fuel oil supplier, and where they suggest that no consideration is given in this provision to the type of laboratory required to test the sample and the accreditation of the laboratory. It is not clear whether these samples tested by international laboratory would be accepted locally. I think firstly, our response would also be further elaborated under Annex 6 below, and our response is that ship owners must ensure their ships use compliant fuels. That's the first thing. Then in this regard, they are required to keep bunker delivery note and samples of fuel oils used by their ships. So the convention, the annex does provide strictly even the amounts that must be kept on board for testing. Remember that the ship would consume oil that it is satisfied meet the standards. So it is to the receiving port, if it wishes, or the administration wishes to test whether the ship the oil that is being used by the ship is compliant. And the fuel samples then are covered under Annex 6, particularly Regulation 18.5 and 18.8.2. Now, there is an MEPC, which is Marine Environment Protection Committee, Circular 320, which specifies that when an administration decides to analyze a fuel oil sample to determine compliance with SAFTA limits in Regulation 14.1 and 14.4, the final analysis should be carried out in accordance with this ISO standard. So this means, therefore, that the laboratory itself would be an accredited laboratory. I think in the case of South Africa, it will be a laboratory that is accredited by SAPS, for instance, so that it meets these very strict ISO standards. So this matter would be further prescribed in the regulation and as currently provided, and the principle of user pays will be applied as is customary. So this now relates to a case where we want to test the oil, the fuel that is used by the ship, and so the cost thereof of enforcement first will be treated as a service to the ship, but also it would be our own prevention mechanism of testing the oil. So, but all these costs would therefore be regulated as prescribed in the regulation. We then proceed. I think this concludes the Western Cape submissions, and I would like to then just draw the attention of the committee that the Eastern Cape, maybe if I could be allowed to just share the response to this, because Eastern Cape had raised the issue of uncertainty as to the availability of port reception facilities. And in this regard, the response that we wish to give...
Just hold on, Mr. Ntuli.
Okay. Yes.
Can we request the committee assistant to give you hosting rights so they're able to share that comment that you are talking about? Honorable Dango, I see your hand is up.
Yes, Chairperson, I was just going to ask a question when the person was presenting.
Okay, Ambassador.
if a ship and two large leisure ships were parked in Cape Town recently, discharges effluent, and the word that he used was that the regulation says that the ship's regulations on board will be the regulations that are observed. Should the local authority or the province or any other authority not have oversight over what is being discharged now? I know that tourism is welcome and we should welcome tourists, but tourists also bring their own consequences. So I think just to be sure that that is covered, and there were two large ships parked in the Cape Town Harbour recently. Thank you.
Thank you, Ambassador. Enrico, did you assign Mr. Ntuli the hosting right?
Yes, Chairperson.
Okay.
Yes, I can see that. Let me just scroll down. Is it visible to the members?
Yes, it is.
Yeah. So here we've just, thank you very much for the question. I'll deal with the question once I've just handled this quickly so that, so here the Eastern Cape was raising the issue relating to the adequacy of sewerage port reception facilities. So this is now in cases where the sewerage that intends to be discharged either has not been treated for whatever reasons, and the regulation then does provide guidance as to how this would be handled. I must as well just indicate that I think this is also linked to the question that's just been raised. You would recall that all passenger ships or all ships must be fitted with the sewerage treatment plants. So it is a requirement, more particularly for all passenger ships, to have such. So an administration of the ship would have then would have approved the treatment, the sewerage treatment facility on board any ship that flies their flag. So when then the ship docks in a port in South Africa, SAMS are then together with environmental affairs and the inspectors would go on board the ship, and one of the things that they would ask to see would be the certificate of the sewerage treatment facility on board the ship. And because all discharges either of oil or of sewerage substance is regulated, so the ship keeps records. So they would be asked as to the records of discharge. Remember that there's a discharge that they are allowed to undertake outside the port limits and off-port limits of a coastal state. So they keep records of this. So the administration then would check those records, but they would not come with a full load of sewerage to discharge in a port. But if then, for whatever reason, they have to discharge a particular amount, the Regulation 11 regulates this by stipulating that subject to the provisions of this regulation, the ship discharging comminuted and disinfected sewerage using a system approved by the administration, which I've referred to, in accordance with the Regulation 9.1.2 of the Annex, at a distance of more than 3 nautical miles from the nearest land. or sewerage which is not comminuted or disinfected at a distance of more than 12 nautical miles from the nearest land. So already they would then have to give account of these discharges, because there is no way that they would not have, considering the journey that they would have undertaken, that there would not be any discharges. All these records would be available for scrutiny. Firstly, on the systems that are being used, and secondly, on the records of discharge, considering the distances that are regulated here. And also it regulates the speed in which the ship should be moving when these discharges are recorded. And these are all have to be accounted for, and they would be able to be inspected by the South African Maritime Safety Authority and other environmental inspectors. The ship has in operation an approved sewage treatment plant, which has been certified by the administration, and to meet the operational requirements referred to in the regulation. Now, the test result of the plant are laid down in the ship's International Sewerage Pollution Prevention Certificate, which then will be available for inspection, and additionally, the affluent shall not produce visible floating solids, nor cause discoloration of the surrounding waters when discharged. So all of these, the discharge is then observed, because it would have been recorded. Now, the provision of paragraph 1 shall not apply to ships operating in the waters under the jurisdiction of a state and visiting ships from other states while they are in these waters and are discharging sewerage in accordance with such less stringent requirements as may be imposed by such a state. So now this relates to local ships that are operating here, that the regulations, because they are regulating international ships, these regulations would not apply to them, but also on the ships that have already been regulated and they are within the waters of the Republic. So these stringent measures are not therefore applied. Now, when sewage is mixed with waste or wastewater covered by the annexes of MAPL Annex of the MAPL Convention, the requirements of those annexes shall be complied with in addition to the requirements of this annex. So this response also covers the fact that all coastal states have to have the port reception facilities for such water, which will be made available to the ships in case where the discharge requires to be treated. In which case, then these are mobile facilities which usually the port authorities, they will contract to outside contractors to come and receive the sewage discharge from ships. This is just another extra safeguard to ensure that no untreated sewage escape or is disposed of within the port limits. I must as well say that until we are able to regulate this in our own domestic legislation, we cannot enforce anything. Even ships that come in, we can just see the certificate, but because we are not parties to the convention, we don't have the power to enforce. And these amendments, then, they're long overdue, and they would give the power and authority to the Republic to ensure that our waters are safe. But until we do that, we are a country at risk. And I thank you for your attention, Chairperson and the members of your committee. Thank you.
Thank you, Mr. Ntuli. That question of Ambassador Dango.
It was
yes, I partly dealt with, yeah.
Oh, okay. No, I think it's fine then. Let's then check with the committee secretary in terms of the. Is Singema also dealing with this one, committee secretary?
Chairperson, no.
All right.
It's Mr. Andile Tejana. I hope I pronounce your surname correctly, Mr. Tejana.
Good morning, Chairperson. Good morning, honorable members, and to my colleagues. Am I audible, Chairperson?
Indeed, you are audible.
Thank you, Chairperson. Chairperson, I'll cut to the chase. I won't waste your time. I know members are very busy, particularly during this course of this silly season. Chairperson, as you are aware, the legislation that is before the committee is primary legislation. I must at the outset indicate that at the risk of preaching to the converted, primary legislation is legislation issued by a group of people who are elected in a democratic manner, and such a group must derive its power to make legislation directly from the Constitution. Chairperson, as a rule of thumb, lawmakers like yourselves can amend, pass, or repeal legislation. However, the Republic of South Africa will from time to time be a party to international treaties and conventions, and such instruments will create international obligations for the Republic. In the subject matter, South Africa is a signatory to the MAPOL Convention, and this places international obligations on South Africa to comply with the convention's prescripts on marine pollution, including the annexes under review, annexes 4 and 6. A cursory look at the long title of the bill indicates that its primary purpose is to amend the Marine Pollution, Prevention of Pollution from Ships Act number 2 of 1986, so as to give effect to Annex 4 of the International Convention for the Prevention of Pollution from Ships, to incorporate the 1997 protocol in order to give effect to Annex 6 of the Convention and to provide for matters connected therewith. Chairperson, simply put, the primary focus of the subject bill is to make provisions of MAPOL Annexes 4 and 6 enacted into domestic legislation. The step that Parliament is undertaking now is to give formal consent to the Convention by making it officially valid. This has already been done insofar as Annexes 1, 2, 3, and 5 of the MAPOL Convention. The standards that are set out in this bill mirror those that are in the MAPOL Convention. Compliance with international standards, as reflected in the MAPOL Convention, is what is at the heart of this bill. Chairperson, South Africa has the principal act as its own domestic MAPOL, which is the Marine Pollution, Prevention of Pollution from Ships Act number 2 of 1996. This act reaffirms the sovereignty of our republic in that it gives South Africa the necessary latitude to regulate marine pollution in its domestic environment. Chairperson, as my colleague from DOT has mentioned, the only issue that is not covered by both the Principal Act and MAPOL Convention is noise pollution, and the noise that I'm referring to is underwater noise. This is a very technical area, as this would require ship owners to change the propellers and the design of their ships. This would be onerous and burdensome for the shipping industry, particularly in the absence of an international standard. The International Maritime Organization has nothing that acts as a guide on underwater noise, and one can imagine the effect on the shipping industry if South Africa were to say that ships whose designs and propellers generate underwater noise should not come to South Africa. This would negatively impact the ocean economy, as there is currently no international instrument that covers this area. Chairperson, if you look at Section 101, subsection 4 of the Constitution, it provides that national legislation may specify the manner in which and the extent to which regulations must be tabled in Parliament and approved by Parliament. This finds resonance in Section 3, subsection 1A and 4 of the Principal Act, as this section provides that the minister may make regulations to give effect to any provision of the convention as applicable in South Africa, and that any regulation made under subsection 1 shall be laid upon the table in the respecting houses of parliament within 14 days after publication thereof in the Gazette, if parliament is then in ordinary session, or if parliament is not then in ordinary session within 14 days after the commencement of the next ensuing ordinary session. Consequently, Chairperson, the DOT has indicated that details relating to issues of incineration of waste at sea, the provision of bunker delivery notes and samples by local suppliers, together with the responsibility for costs associated with sampling and the overall management of the process will be provided for in the regulations. The committee will have a second bite at this, as the above mentioned provision makes it peremptory for the minister to table the said regulations in Parliament for approval. This will ensure that the said regulations go through the parliamentary process prior to their promulgation. Chairperson, the bill that is currently serving before this committee seeks to amend the Principal Act so as to give effect to Annexes 4 and 6 of the MAPOL Convention. These are minimum standards which South Africa has to comply with in terms of international obligations flowing from it being a party to the MAPOL Convention. This is the end of the matter insofar as this bill is concerned. Chairperson, notwithstanding the above, if members of the view that certain areas in the Principal Act, which is the domestic MAPOL, in which they wish to impose stricter measures than those that are specified in the MAPOL Convention, nothing impedes them from doing so, and such an opportunity will present itself when the said regulations are tabled in Parliament for approval. Thank you very much, Chairperson. We are aligned, Chairperson, as legal services with the Department of Transport. Thank you very much.
Thank you, Mr. Tishana for the inputs. I guess want to invite members, but I needed to present. Would want to have notes on what you have just presented, because we have an opportunity next week to finalize the Transport Appeal Tribunal's bill. It would be nice if we can have those notes that you've just presented. That will put us in a much more better position as members, as you've correctly pointed out that in terms of constitution, we are legislated to make laws, and definitely in view of the technical nature of this bill, it will help us to ensure that we are all at once in terms of the advice from the Parliamentary Legal Services side.
I'll do so, Chairperson.
Thank you. Honorable Dango.
Yeah, Chairperson, I'm sorry I've asked lots of questions today. My question is the following. If a warship is parked outside and no war is declared, and the noise abatement from the bombs continuously carries on, is there an international convention that actually regulates this? Or should there be such a regulation? I say this having experienced this in Tripoli in Libya. There was no war declared, but the warships for months incessantly bombed, and we had to live with the noise abatement. Thank you, Chairperson.
Thank you. Honorable Khair.
Thank you, Chair. My question are on the procedure, Chair.
Yes.
And I need clarity from both the department and the legal advisors. That in my understanding, in terms of the bill, there are 7 clauses, and that we need to apply ourselves to, but also including the provinces in terms of their provincial mandates. And and therefore, for me, the clarity is that there are these annexes 4 and 6 of the IMO. My understanding is that if there are to be any proposed amendments, those amendments would be considered at the level of the IMO, not in this particular bill. My understanding is that the schedule with these annexes was more of a information as we, as a committee, consider the implementation by South Africa of the provisions of the convention. They take into account that there are these regulations as per the annexes 4 and 6. That's my understanding. I was not of the view, therefore, that there would be proposals around amending them, because I don't think we do have a jurisdiction at this stage, not unless then there would be a meeting of the IMO, and then South Africa is then invited as a party to the convention to make proposal on the amendment of the regulations. And then the committee would then invite the Department of Transport on the regulation that would be then proposed to the IMO. It is only then that perhaps then the provinces and the committee, as well as a committee, would make proposal that South Africa should then take into account when those proposals are made. And even at that stage, there's a clause that says, even if then the IMO makes those amendments, what then would happen is that this bill empowers the minister then to amend, based on the amendment that comes from the IMO, then to amend the regulations in the form of a gazette, because they would have been amended at the IMO level. That's my understanding. And therefore, instead of making another bill, bringing another bill to Parliament, all that she has to do is to gazette the amendments. I think that's what one section of the bill says. So therefore, I was thinking in my mind whether the process that we've just come out of, where the department was responding to the proposal that are directly linked to the schedule and the regulations, whether it was worth doing so, because it's not going to amend those annexes, because we don't have that jurisdiction. We can only make input then when we deal with the regulations that then the department will table. Not now, as the legal advisor is indicating. So I just wanted clarity on that, Chair, because I thought that ours was just to be limited to those 7 clauses or sections that are in the bill, and therefore the annexes 4 and 5 and the regulation for now are to sort of like inform us that, for example, the definition that is being proposed talks to the issue of the convention, and then if we accept that, then we accept. Once we accept, then following that, the issue of the incorporation, it is there in the clauses, but then the rest for me is more of an information of, as the government is implementing this amended bill, it has now taken into account the convention. It will then be domesticating the convention. So I hope I'm clear on what I'm trying to also get clarity on, Chair, in terms of the procedure. Thanks very much.
Thank you, Chair. Let's start with the department, and then I will then go to Mr. Tijana.
Thank you very much, Chairperson. And yes, indeed, I think I was listening to Honorable Rai, and as he was asking, but he was also educating everybody to understand the, I think, the purpose of dealing with this bill. Yes, indeed, the text that is in the annexes 4 and 6 is a given text. We don't have any authority to change that text, but the reason why we had to give attention to the questions that were raised and recommendations that were raised from two provinces, that's Western Cape and the Eastern Cape, was just to explain why we are not accepting the proposed amendments, because we are constrained, because as we have as it's been reflected here, that the convention was negotiated already, and South Africa was part of those negotiations and agreed with the text. Now, remember that these annexes that we are incorporating now are part of the MAPOL Convention, which went through the acceptance process, and South Africa, the executive being given authority by Parliament to accede to the convention. So it's really now giving effect, because Section 231 of the Constitution requires that before an international agreement becomes law in the Republic, it must be domesticated, and this is what we are doing. But what we are doing is limited in terms of what we can do, is restricted. We cannot change what is in the annexes and appendix to the annexes 4 and 6. I thank you.
The question from Ambassador Dango, Mr. Ntuli. The war.
The question, the war, the war. We are so, I think, glad that we've got the honourable member safe and sound here in the country. So, but as for the application of these agreements on warships, I think there is an international agreement that these does not strictly apply, but those ships who call in South Africa are required to comply with the marine pollution convention, with marine pollution prevention regulations. So as for only for marine pollution regulations, they are expected to comply. So we can do an enforcement, but the enforcement will be different, because it will be an enforcement through diplomatic channels. So there is a degree of flexibility that is applied, or that is granted to visiting warships in each of the countries, more especially if you've got a bilateral agreement with a state. So you will be notified in time on the requirements for the visiting warship, and these will then be granted through diplomatic channels. So at least we would have been pre-advise as to the type of ship that is coming and what it is carrying and what safety measures that would need to invoke. So it's not that they just arrive, but there are some controlling measures through the diplomatic channels. I thank you.
Thank you, Mr. Tichana. Mr. Ntuli. Mr. Tichana, the floor is yours.
Yes, Chairperson, I don't want to be a party pooper, Chairperson. I think Honorable Khai and my colleague, Mr. Ntuli, have done all the work, Chairperson. Chairperson, we in the words of Honorable Khai, we are just domesticating the convention here. And if you look at section 231, 2 of the Constitution, it says an international agreement binds the Republic after it has been approved by resolution in both the National Assembly and the National Council of Provinces. So, Chairperson, it seems as if we are chasing a goose that has been caught, cooked and eaten. Thanks very much, Chairperson.
Thank you, Mr. Tichana. Members, do we agree that we will then deliberate next week once we have the written response from Mr. Tichana? Because it's quite clear, it makes things much more easier for us. Just want to get the views of the members on that. Can I then agree? Can I then take that there is consensus on that? We have sufficiently dealt with today's meeting. I mean, today's 2 items, provided that we expect that we'll finalize these 2 bills in terms of the negotiating mandate next week, Wednesday. Next week, we will be guided by the parliamentary legal advisor and committee secretary in terms of the concern that was raised from Ms. Ngema, that on her table also is the Bella bill, which probably might be sitting on Wednesday. So therefore, there's a likelihood that we might be meeting on Tuesday. So we'll get guidance from them on that. But also, as I suspect, then that will put us in a much more better position than to deal with the deliberations and then send the report to provinces where there is a need. But what is important is that the province has to give us the final mandate, so that we are then able to deliberate on the report, on the final mandates, and then take it to the plenary. Let's then move to the next item on the agenda, which is the minutes of the last meeting that we had. Our guests are at liberty to leave now, as we are dealing with the in-house matters.
Thanks, Chairperson and honorable members.
Thank you, Chairperson.
Thank you.
Goodbye.
Members, we are dealing with the minutes of the 24th of April, where we were dealing with the negotiating mandates on the railway safety bill. Those were the attendees. And then our guest from the Department of Transport, and also the PLOs from our provincial legislatures, and then the parliamentary staff. The reflections that were made at the beginning of the meeting, and then apologies that were recorded. And then we reflect on the proceedings that ensued, capturing the pattern of how the provinces negotiated around the railway safety bill. Deliberations that took place. Those were the inputs that were made. And then we dealt with the minutes of the 27th of March, the 17th of April, and then the meeting was adjourned. Can we then get an indication as to whether is there any correction, subtraction, or addition? Is that a legacy and Honorable Dango?
Indeed.
Then get a move for the adoption of the minutes?
I move for the adoption of the minutes, Chairperson.
Thank you, Ambassador. Can you have a seconder?
I second, Honorable Chairperson, Honorable Mshodi. Thank you.
Thank you, Honorable Mshodi. Therefore, the minutes are duly adopted. Let's then formally take this opportunity to just sensitize members that probabilities are that we might be meeting on Tuesday, taking into account the concerns that was raised. But of course, mindful of the fact that at least half of the job has been done. So it will be deliberations on the two bills. And then it makes things much more easier, you see, if when we meet, members had an opportunity to also go through the advice from our parliamentary legal services, because as lawmakers, it's always important that our processes are infused with the results that we have at our disposal in terms of advice. So it makes sense then to get those responses on time, so that we go through them, so that it makes things much more easier when we engage with the matters before us, but also it enhances us in terms of the output of the deliberations that will be our end results. But having said that, members, let me also then express a word of gratitude to yourselves. We know it's a bit tough, given the hectic programs that we have, but your commitment ensures that we are able to at least reserve 2 to 3 hours just to process these bills, because they are quite critical and of critical importance, very technical, but very, very worthy of processing. And then also a word of gratitude to the departmental staff, the managers that appeared before us, and also our parliamentary staff, our communication team, and our public at large that are watching this in terms of the live streams. So therefore, the meeting is adjourned, honorable members. Thank you.
Thank you, Vice Chair.
Thank you.
Thank you.
Recording stopped.